assume you can have a week to figure this out.
Judge, they've had since December of '23. They didn't even have the courtesy to inform us of a pending investigation. We had to learn this from Apple.
Well, it turns out that YNW Melly has emotions today, but emotions couldn't be heard because we just found out 2023, one of the lawyers, I guess, was not even supposed to be on the case this long in because she has an active investigation, which we believe is for witness tampering, but we don't know because they haven't told anybody. Man, it get real messy. I'm talking about tornado to your house messy. Let's just get into it.
Cases, federal cases, because state court really hasn't delved into this area as much as the federal case law does, indicates that there are certain things we need to find out first of all. So I don't know if this is the hearing or you want to set a hearing, but the bottom line of it is that the first thing we need to know whether Miss Liberty is still under investigation. We were told before the hearing by the state, and I have no reason to doubt their word, that she still is under investigation. So that raises for us a number of problems. It may look on the surface that the only thing is, does Miss Liberty need to get permission from Mr. Devins to stay on the case and for him to waive conflict, but it's much deeper than that. And the reason why it's much deeper than that is we don't know what the state has subpoenaed. We do not know what they have in their possession. We do not know, other than the Apple accounts, if they've subpoenaed other things. Therefore, we do not know whether communications that we have had with Miss Liberty have been intercepted, and therefore, we've been told that nobody else on the defense team is under investigation, but there are certainly confidential communications that we would have had with Miss Liberty. There are communications about trial strategy that we would have had with Miss Liberty that we do not know who is in possession of them, what is going on with them. Now, the case law seems to be pretty clear that during this type of process with an attorney who's on a case, that the state is bound to return innocent or innocuous or confidential communications to Miss Liberty. But she has not received any. In fact, she didn't know there were any that were to be received until the date that's mentioned in the motion. So where does that put us? As I said, we've been told that the defense team, other than Miss Liberty, is not under investigation. But we do know that there's an ongoing investigation. What we have now been working for nearly a year, or over a year, with the state being in possession of documents dealing with Miss Liberty. If in fact Miss Liberty has to get off the case because of the conflict that she would have, this is a year too late. We should have been informed of this a year ago. So the defense team and Miss Liberty, and therefore Mr. Devins, for a year are working on this case with the state knowing that there's the potential that Miss Liberty will be indicted or an information filed against her in the exact same case of tampering with evidence and with witnesses. And if that becomes the case, she obviously, whether there's a conflict or not that's been waived up until that time, I think the case law is pretty clear. At that time, if she has charges against her, she has to bail out. In fact, I believe, and I'm not sure because it's federal case law, but I'd like to read to the court this paragraph from the case of U.S. versus Shagan, 661 Fed Sup 1289, 2009. In contrast to McLean, where the defense counsel was under investigation for a crime unrelated to charges against the defendant, here, defense counsel would have been under investigation for crimes that threatened the integrity and fairness of the trial. Were the government to inform the court at the eve of trial or during the course of trial that the defense team was under investigation for witness tampering, under the principles of McLean and as conceded by Cronin, the defense team would be forced to withdraw its representation of Dr. Shagan. In fact, David Marcus made the motion orally as soon as he heard about the investigation. Such a development would have deprived the defendant of a defense team that had been intimately familiar with his defense, causing him severe prejudice. And that's where we're traveling down right now. even if we stay on the case right now, if charges are brought against Miss Liberty, and they happen to fall before the end of Mr. Demon's trial, we may be forced to, under the law, to withdraw as an entire defense team.
So the real question is, yo, why are y'all doing this now? Because I think the state may be hitting them with that petty grease. Because if you remember, the state had to basically remove their head person because she just became a freaking witness in the trial. So the blonde-haired lady that you see now is not the lady that was who we were used to. We used to the lady who, I'm going to be fair, has zero sense of emotional tone. She couldn't convey the right words in the emotional intelligence that you need to. See, it's one of those things where there's a subtle art of public speaking that you need to have when doing certain things to elicit emotions that you want them to feel, such as the pain of whatever crime happened to the other person or the anger that you may feel from having something taken from you. Just those things alone are supposed to do something for you. But in this instance, she didn't have any of that. So now we got to sit back and wonder, hey, bruh, why are we doing this now? Basically a couple of months out from the trial, because he's right. Hey, man, listen, some BS can happen and then we all have to withdraw. And it seems as though y'all still trying to concoct y'all case so y'all can figure out how, one, y'all didn't answer these motions. All y'all did was ask for extensions on these motions. Buddy been in jail for I think the judge is going to reveal 1,165 days or something like that. The actual number will come out pretty soon, but let's just keep on going.
But a question still needs to be asked. Why did the state wait, not to tell us, because they never told us, we had to find it out through Apple, that there was an investigation? Because a year ago, we would have sat with Mr. Devins, and he may have said, you know what, I need a new defense team. And we would have been off the case. But for a year, basically, we've been on a case that maybe we should not have been. There are things that we need to know. We need to know who reviewed the warrant, who signed the warrant for the state as far as authorizing. We need to know whether there was a tainting. If all this information was gathered and given to the state attorneys that are prosecuting this case right now, there are innocent, innocuous, and confidential communications that will be in the hands of the state that is improper. A tainting should have been set up that reviews the documents and makes sure only those that are specific to the search warrant are looked at by the trial team. Questions need to be asked. If in fact Ms. Liberty is under investigation, then why were the subpoenas sent out and why did that investigation begin now? And what I mean by that is there's a statute of limitations. The state was under no obligation to begin that investigation until Mr. Demmons' case is over. Therefore, there is no perceived conflict. There is no conflict because we don't know that they're thinking about investigating Ms. Liberty. But instead, we were not put in that position to know that, and a year went by. If they had waited to the conclusion of Mr. Demmons' case, as I said, then there is no conflict. So the only thing that I get from this is that there's the chance that within the next whatever year, or 10 months until the trial date, 9 months, whatever it is exactly, that Ms. Liberty is in fact facing charges for him. And if that occurs, then A, she can't try the case. Not sure the rest of the defense team can try the case. And don't know, and a prejudice to Mr. Demmons would be monumental that at this stage you have to get a whole new defense team. So we need these questions answered. It's not just a simple, is there an ongoing investigation? We need to know the extent of it. We need to know the whys of when it was instituted and why wasn't it, why didn't the state wait for this matter to be over? We need to know whether the state, if they're going to charge Ms. Liberty with this crime of tampering, do they intend to try her at the same time as Mr. Demmons, or a separate trial? Obviously, at the same time, it even raises more of a conflict. have a question, and that scares us. Miss Liberty has not been allowed to see Mr. Devens in person for the last, I think before I got on the case, for at least the last year and a half. When she goes to the jail, she must pick up the phone and use one of those phones to talk to Mr. Devens on the other side of the glass partition by phone. Have they been tapped? Have they been listened into? We need to know what communications, what has gone on. So it's not just as simple as, is there an open investigation? Now, as far as going forward on these other motions that you said, we can't go forward as a defense team on any of these motions until we talk to Mr. Devens and have him understand what's going on. And for him, first of all, to make the decision. Yes, I want to keep this defense team. Yes, I want to keep Miss Liberty. Or no, I need a new defense team. We can't do anything until that's decided. I will say that after doing the research that I did over the weekend and came up with the case I cited to the court, I think all members of our defense team need to call up the Florida Bar and to see whether we're obligated, now that we know that she's under investigation, that we're obligated or not to withdraw from the case, regardless of Mr. Devens' position. So that's where we stand today. With all apologies to the court, though, I do not believe we can go forward with these motions. Mr. Devens has a lot of thinking to do. Hopefully the court will give us a hearing where some of these questions are answered, and then he can make a logical and an informed decision. And by that time, we can find from the bar whether we have obligations regardless of his decisions.
Rutledge says, I have to find out if there's an investigation, and the state says there is. What is your authority for all those other things that you say you want to answer? Because I didn't find any authority in that. I don't even know how I would do that. Well, do you have any authority? I understand you're saying, after judge, this is what we like. I read what Rutledge says, that's what I'm doing right now. But you want to know about investigations, you want to know about a judge who reviewed a warrant. How would you suggest I do that? And more importantly, do you have any authority that supports any of those requests you just made?
Well, the authority that I have, Your Honor, is the Sixth Amendment to the United States Constitution, which requires and which allows my client to have competent counsel. And without being able to go into these things, and I also rely on the 14th Amendment due process, without being able to go into these things and have a hearing where all these things are ferreted out.
A hearing, that's what I'm asking. What do you, I don't want you to confuse some type of hearing defending this liberty. That's not really the issue. That's a yes or no question. Is she under investigation? And the answer is yes. So the only other question that Rutledge requires is that Mr. Devens has to decide, does he want to go forward with her, or does he want conflict-free counsel, which I think he's certainly entitled to. And if he wants to apply that to all of his lawyers, he may do that. But that's a discussion between you and your client. I can't intervene in that. You're asking me to do fact-finding on behalf of your client so your client can make an informed decision.
Well,
Right.
then I will file another motion for prosecutorial misconduct and ask for a hearing on that. And subpoena witnesses in. The state will move to quash the witnesses that I will be calling in, and we'll have hearings going down that path.
So, yeah, I mean, at this point in time, you do. When you're saying that the state is essentially playing dirty and they're playing dirty on purpose, yeah, that would qualify. But the problem is which in which you have to prove. See, they may have case law over there on the state side to say, we ain't had to let you know about any of this stuff, and y'all all may be dirty. But you already got one person booted off. Why not go for two? It just is what it is at this point in time. So if y'all wondering, like, why would he say that? Because he has to. Because at this point in time, you can't say, we're doing this work project. Let's just pretend everybody that's watching, we're all at school and we all have a project that's due. And somebody on our team is accused of cheating. Now, mind you, we could still go on ahead with that, but your teacher is the only person who knows that that person is accused of cheating. And before you get ready to present your freaking project, the teacher say, hey, yeah, I've been informed that little Johnny over there has been cheating. And who told you that? Yeah, little Lucy over there. Little Lucy, she the one who told me that little Johnny over there has been cheating. Well, teacher, when were you going to tell us this? When? Why would you want to tell us this right before we present our project? What was the point of this? And teacher, when did you know this? Oh, you can't tell us. Well, shoot, turns out that we actually knew about this too. We knew about this right when we were getting started on the project. So why wouldn't Miss Lucy sit up here, since she accused it, and you were sitting up here teacher-wise, sitting up here with this information and lurking on it? Not saying that this judge knew about it, but a judge does have to sign off on this stuff. So you do have to wonder about that part. That's why he's asking about the judge. Like, we got to find out which judge signed off on this warrant, because we need to know exactly what the heck is going on. Not necessarily the intricate details, not at all, but you do need to know some point of everything, because what they're saying is, shoot, the state might know our playbook and you can't have that because that's not proper. So file another misconduct, it just makes sense on my behalf, but let's continue on.
This is something, no offense to this court, but I do not know how this court says that's the only thing that matters to me. There's a whole laundry list that deal with not only conflict.
That's what I'm asking. Do you have any case law that tells me I have to do that? I'm happy to do that. You cited Rutledge, and I read Rutledge. Rutledge doesn't
I
say
have
any
no
of those
case law in
things.
front of me right now that says you have to do that. But I would think it would be the inherent authority of this court that you should do that. And there's certainly nothing that says you can't do that.
That's usually that podium that talks to me about my inherent authority, which I don't exercise. I'm happy to do whatever a statute, case law,
Well, let's-
criminal procedure tells me to do. I don't make up things on my own.
Then I ask the court, let's go one step at a time. Right now, Mr. Demmons now has been informed that Ms. Liberty is under investigation, and let us see what he decides. If he doesn't want us on the case anymore because of this, then all the things I've raised will be raised by another set of counsel. But if he does, we will be filing other motions in order so that we can get these questions answered, because Mr. Demmons needs to know these before, quite candidly, he can make that choice. Now, he can say right now that he wants Ms. Liberty, but after these facts come out, depending on what those facts are, he may decide he doesn't want Ms. Liberty or the rest of the defense team. So we'll take it one step at a time.
So your request is you want me to hear any of these today? And
I don't think we can.
when would you like me to reset?
I do not know how long it will take. Ms. Liberty is not in town yet right now. She's on a plane. She got snowed in Montana yesterday. Drove from Montana to Seattle. She was on an airplane ready to come here, and they canceled the flight while she was on the tarmac. She got another flight including Phoenix. She's now on a plane from Phoenix to here. Almost all these motions that you went through are Ms. Liberty's motions. So A, for logistical purposes, we can't hear those motions this morning at least. We're hoping that she's back at 1:30, but I do think it takes some time for us to talk to Mr. Demmons. She certainly needs to talk to Mr. Demmons. So, you want to reset it for, I don't know if we can speak to him tonight sufficiently or not. You want to put it on for possible motions tomorrow and status tomorrow? You can, but I'm not sure that's enough time to talk to him.
It's not enough time, quite candidly. And we need, if I may be heard.
Yes, sir.
We need to file, based upon your Honor's comments, we need to file a motion requesting certain things about this investigation. Concerning the paint team, whether or not they relayed any of that information to the prosecutors or the investigators in this case. And I want the court to know, they didn't tell us. Apple informed Ms. Liberty that a search warrant was issued on her Apple account back on December 13th, 2023. As a result of that, I contacted the Broward Sheriff's Office and spoke to Christian Sabanis. And I sent him a text message that said, I was just advised that Broward Sheriff's Office issued a search warrant on Ms. Liberty's Apple account on December 13th, 2023, over 1 year ago. I would like to discuss this with you. He responded by saying, hi Stu, I have zero knowledge of this search warrant or its application. Your email is the first I have heard of this. I would defer to whoever the affiant was. I don't have access to that information. I in turn contacted the state, and they said they would get back to me, which I spoke for the first time this morning to the state concerning this. I think we need to know the procedure of the so-called paint team so that any privileged communications were not relayed to the prosecution team and or its investigators. We also need to know since Miss Liberty represents numerous other clients, whether or not they have severed or separated those privileged communications that have nothing to do with their so-called investigation. We need to find this out.
Well, do you even know the investigation has to do with this representation? That's exactly what I was just thinking, what you just said.
I assume it is since it's issued from the Broward Sheriff's Office.
How do you know it isn't related to one of our other clients or one of our other cases?
Well,
Has
that's all I
anyone said
have.
anything that this has anything to do with Mr. Dennis?
I can't answer that without seeing the search warrant.
And we're not here to make work. Does this have to do with Mr. Dennis?
It does, John.
Okay.
So can you give them a copy of the search warrant?
No, because it's a pending investigation that's still ongoing.
How does Mr. Demons make a decision about whether he wants to waive any potential conflict or not without having that information?
The only thing I can say, Your Honor, is again, it's a pending investigation. Knowing that she's under investigation is what Rutledge talks about. You can't give anything over until it's
Well,
officially completed.
With all due respect, but this is the high due process part when the state's seeking the death penalty. The state's seeking the death penalty. So you need to turn over the affidavit and the search warrant so the lawyers can make an informed decision. All right?
It does not have to do with the homicide case.
Well, in any case, he needs to know if there is a potential conflict of interest. He's either going to make an informed, intelligent waiver of that, or she will no longer be his lawyer. And then he has to make the same decision for all of his other lawyers. And he is going to trial September the 10th, 2025. So we need to do this now. So how long will it take for you to get a copy of the affidavit and a copy of the search warrant and give it to opposing counsel?
I'll speak with my office and you can have a week to figure this out.
Judge, they've had since December of '23. They didn't even have the courtesy to inform us of a pending investigation. We had to learn this from Apple.
And that Judge Ball's got to be small as hell, bro. Like, I ain't gonna lie. When prosecutors talk like that to judges, that just let me know that a prosecutor believes that the courtroom is theirs. They don't believe that the courtroom actually is of the people and to be ran by the judge that the people deem right because these judges get voted in. Nah. You see what she just said? Basically, like, nah, you can wait a week. I don't know, bro. I'm already not liking that, but that just seems to come with the entitlement of most freaking prosecutors. Why that is, I don't know.
But you're telling me it relates to this case.
To the tampering case.
So why would this be different than any other search warrant in any other criminal case? The defense counsel would be entitled to it.
Because she's not a subject that's been charged yet, potentially could be. It's pending investigation. All I can say is, again, pending investigation, there is a team in place, and it's still pending. So it's not like we have to hand over discovery to her. She's not a listed defendant yet.
No, but let me repeat myself. Mr. Demons has to make an informed decision about who he wants his lawyers to be. He's now been sitting in our jail for 2,159 days. So how long would you like to be able to make that decision?
I can't determine when the investigation will be over. That's up to the Broward Sheriff's Office, but I can, as I said, I'm just asking for a week to determine whether or not we file any sort of motion to prevent the search warrant from being over.
I just can't imagine any legal grounds that would not happen in this particular case. It's a death penalty.
I understand that. And then I'm asking for at least a day or two, at
Can you
minimum.
decide by tomorrow? I've also reserved all of tomorrow. I took over Division FT. Judge Murphy had 44 pending first-degree murder cases. I've set them all for trial. I'm booked to trial through July of 2026. So if you all think I have 2 entire days at some point in the next 18 months to do these again, I do not. So
Understood.
I'm not sure what it is you want me to do. You don't want me to do anything else today.
We can't under the Florida rules.
So do you want me to leave them on for tomorrow? You will have the balance of today to discuss all these issues with Mr. Demons, and state you will have the balance of today to discuss some reason why you can't just turn over this affidavit and search warrant?
That's
I
fine.
mean, it may be something innocuous. By the way, for the record, I don't know anything about this. No one brought me a search warrant, so. But maybe it's something so de minimis that Mr. Devens is gonna say, that's fine. If there's any conflict, I'll waive it, and, let's get to work. Or if not, I guess he's gonna have to go find 5 other lawyers to do this, who are gonna be ready to try a capital case in 9 months, so. How about tomorrow at 9:30?
We'll be here.
State tomorrow at 9:30?
That's fine, Judge.
And it can't, again, I'm not picking on you, but the answer can't be, my office told me X, Y, Z. Someone better be standing here with some authority that tells me they can't do it. Okay?
Judge, one other thing.
Yes, sir.
You mentioned about the trial schedule, and we're obviously going to try to do it. I just want to let you know, the matters that were appealed are still up in front of the court DCA. The state, I believe, just filed the last document in the case, or there may be one more that they need to file, one more reply brief. I would suspect that it's going to be set down for oral argument, and then I don't know when we would get a ruling. The problem is, the stay that was issued by your previous judge, we cannot go into anything on any type of discovery as far as depositions, as far as motions, as far as anything dealing with the matters that are up on appeal. So when that all comes back, we will be rushed to get everything else done. Just want to let the court know, we're under the mercy of the fourth.
Is there anything pending at the 4th DCA regarding the tampering?
Yes, everything that was on the homicide is also on appeal for the tampering because it's the same evidence.
Yep.
And Judge Murphy entered an order.
Entered an order that says you can't do depositions?
We can do depositions on things that aren't on appeal. So we have been doing depositions on things that aren't on appeal.
For example, you did not read, unless I missed it, but there's a motion in which I'm asking the court to make the state tell us what of the 2 million or whatever amount of Instagram messages they intend to use at trial. That was filed a long time ago. We can't have that hearing because the Instagram messages, the whole thing is up on appeal. So we can't even go into that motion. Those are some of the things that await you.
Well, can I give you rulings on all those, depending on what, if I rule some messages are in and some messages are out, your example, and the 4th DCA says they're all out, then they're all out.
Judge, I wanted to move this case. I'm just.
Do you have any objection to doing that?
We're not the ones that filed this day.
Do you all have an objection to doing that?
Well, I think I'm confused on the motion that you're bringing up because all of the Instagram, if I remember correctly, I have to look, is up on appeal.
Right.
So, I mean, it would kind of be a waste of time to do the motion.
Oh, no, a waste of time is reserving 2 entire court days and doing nothing. That's a waste of time. So do you have any objection to going forward and you hearing and ruling on any and everything that's pending?
I think that we should start with the things that don't affect the appeal, and then, because there's plenty of those to be heard, and then we can go forward potentially with the other ones.
And I'll be candid, I did not think we were hearing the Instagram matter whatsoever. So I'm not looking at that motion.
Okay, so why don't we do it this way, all right? He's gonna remain on the docket tomorrow. I have a few other matters on both FX and FT, so let's call it 9:30 tomorrow.
Yes,
And,
sir.
defense, you can come in and tell me if you had a chance to talk to your client, because if he's gonna waive any potential conflict, then I guess it doesn't matter.
Yes, it does, Your Honor, because he'd be waiving a conflict without knowing what's in the search warrant affidavit.
Correct.
So therefore it would be an invalid waiver because he's not totally informed of the facts.
Okay, you're gonna tell me what you wanna do, state, maybe you can identify the motions that you think we can go forward. I mean,
We sort of addressed it in the motion to strike the notice because we've been asking since our hearing in October to know what motions are going forward the next 2 days. Couldn't get an answer. We've asked in depositions from Ms. Liberty, couldn't get an answer. We emailed, we couldn't get an answer. And then just a few days ago, we got a notice of hearing. Half those motions aren't even filed within the court file in Odyssey. So we identified, I think, 4 that we are ready to go on, that we filed responses on. There's no motion filed for some of these
you can
titles.
go to
that-
trial in September. All right. I'm not prejudging things.
I hope so, Judge.
No, I can absolutely guarantee you, he's gonna go to trial in September. So I'm gonna do everything that I can. If I have to rule on things during trial, which is an awful way to do things, because I know you both know, but if that's what it comes to, then that's what we're gonna do, so.
Assuming we're still on the case. And that's a big assumption at this moment.
And just, they're still asking for proper notice of what we're actually going
I
to
did,
hear.
well, I'll take the blame for that. All pending motion. That's why I put that down for the tomorrow. All pending motion. They're asking for I believe, they're asking for a Daubert hearing on cell phone records. They're asking for a Daubert hearing on some other matters, cell phone mapping. There's a whole bunch of things that.
Some of those have already been ruled on, Your Honor. The ones that they've noticed, I think, and again, Ms. Liberty admitted to this the last time we were here in front of Your Honor, if she filed things with the wrong case number or wrong title, she's going to fix that. None of it has been fixed. So the state is entitled to proper notice so that we can respond accordingly.
We'll see you tomorrow morning. Fair enough?
Okay, I'll see you at 9:30 tomorrow. Ms. Wilcox, does that otherwise conclude FX and FT for today? Okay, so the FX and FT are both going to otherwise be recessed until tomorrow, which is?
Excuse me.
Yep, yes, sir.
I've been told that Mr. Devens has federal court tomorrow morning on his civil hearing. Does corrections have any idea of that?
Not tomorrow, sir.
Huh?
It's not tomorrow.
It's not tomorrow?
I believe it's January 17th.
17th. Forget what I just said. Thank you. We don't represent him on that.
Tomorrow is Tuesday, January the 7th. FX and FT will be recessed until then at 8:45 a.m. I hope you all have a good rest of
Thank
your
you.
morning. All right, Mr. Court Reporter, that is it.
Now, I think, this is just a thought. I think this has to do with Cortland Hearing, aka YNW Bortland, and the tampering and stuff that they're going to allege that the lawyer from YNW Melly's team leaked information to Bortland about the witnesses or something like that. I don't know, Brett. It all has to do with witness tampering. And that's that. She's under investigation. She has not been charged or any of that crap or anything like that. So that's essentially what they're saying is, they're saying, hey, we're putting y'all up on notice that she's under investigation for witness tampering. They're not trying to say it like that, but that's 100% what it is. So there's that part. Added with the fact of this. Y'all supposed to let them know. Like, it makes zero freaking sense because if this was, let's just say this was you, right? And let's just say you had a lawyer and your lawyer had a team, somebody on your team. And next thing you know, finds out, hey, this lawyer been doing dirty work behind your back. Are you going to say, yeah, let's keep this going? You're going to say, hey, bruh, y'all about to put a black eye on my reputation to the freaking judge. So now y'all got to bounce. Now, all in all, I don't think YNW Melly puts them people off of his case, off of the team and stuff like that. Maybe her, she got to go because you can't. One thing you can't do, and we know YNW Melly 100% ain't listening to this because he's in solitary confinement. Just is what it is. So we already know 100% that we don't know what he gonna do. He said he got split personalities, so I don't know. Would I do it? Nah, we already got too much skin in the game. Y'all done already, quote unquote, beat the state before. Now people will say, well, there was a person in there that was bullying and all this crap and everything like that. Maybe you should just believe wholeheartedly that they made the case and it just is what it is. But the fact that the matter still remains, YNW Melly still has his September trial. It's going to go through. It doesn't seem like anything that he's filing motion-wise is going to be granted because you're facing a double murder with the end game being your ass getting your life taken. The state is seeking the death penalty. F what you're talking about, F what you heard. They're seeking to get rid of his ass. So you ain't got to worry about nothing else. If anything else, they're looking to X his ass out of here. So that's why they're not going to do it, bro. The charges are far too stiff. I don't care how anybody try to spit it. Oh, he's innocent, and all that. And he may be innocent. Even if he's innocent, unfortunately, them charges that he is alleged to have committed are some tough, stiff-ass charges. Because if you look at it from the other side of the map, bruh, had this been anybody else that does not have a name, fame, and music that you like, would it really be so bad to keep their asses locked up until we figured this whole entire thing out, that they didn't get bail? Because if they murdered once, they'll do it again. He has 2 murder charges, so they're going to assume he'll do it twice. And that's just what it is, bro. So I don't think any of the motions that he has filed are going to do anything. They're basically saying she's not even charged with anything. I think that the state is saying this to kind of make the defense scared, worried, all of that crap. But if I'm the defense, I'm thinking to myself, hey, bro, we in good positioning because y'all trying to get us up out of here. You wouldn't try to get me up out of here if you didn't fear me, if you weren't worried about me, if you didn't think that I had the ability to beat you. So, nah, that's like how the Chiefs just lost to the freaking Broncos yesterday. Chiefs lost to the Broncos flat out because they knew they didn't want to face the doggone Cincinnati Bengals, because the Bengals more than likely will put up a bigger fight and better fight to get to the Chiefs and whoop their butts. It just is what it is. We're not even whoop them, but they got a better chance of winning that game than the Denver Broncos would or the Houston Texans would. So we'll see, bro. I don't know, man. But share to keep your people aware. Subscribe, turn on bell, stay notified. The reason why you want to do that, because it helps the channel grow. And also, put the comments up in there. I see y'all like arguing. So if you like arguing, leave your comment, leave a like, and watch people get at you. I don't block nothing nobody say. Y'all see what the weirdos type against me? It's all love over here, baby. But I guess I'll see y'all tomorrow morning.